Hey, good afternoon. Wanted to touch base about a few things that came up in the practice recently, and that is the interception of electronic communications and the introduction or prohibition of the introduction of intercepted messages in a case, especially as it relates to criminal and possibly family law situations, which is where most citizens are going to encounter this kind of. In this video series, I'm going to discuss how the Federal Wiretap Act came to be, what it originally prohibited the interception and introduction of, and then how that's been changed over the years as our technology has moved along. Now, everybody knows that back in the day, the feds would wiretap, and they still do to some degree, to the number of people who still use landline communications. Those phone lines can be tapped with certain warrants, making a showing to a federal agent, probable cause showing that there's need to surveil and monitor somebody's communications. Those communications, like anything else, you make a request to a judge, judge approves or denies, and then the monitoring equipment goes into place. That was kind of the concept under the old Wiretap Act. Wiretapping didn't protect radio communications, and then later, as technology progressed, cellular communications, because those are being transmitted through the air. Our technology has changed. There's been some changes in our law to protect privacy rights of citizens, and that has been addressed so that cellular data communications traveling through the air now fall within this new, broader, more expansive definition of communications under the old wiretap statute. I'm not going to get into all the statutory minutia, but really want to explain how it applies more commonly or most commonly for an average citizen to a case they might encounter, which might be a criminal law case, but more commonly might be a family law situation.